Very much. Can I just check, is everyone able to hear me if I don't use the microphone?
Yeah.
Well, can I just begin by thanking Eleanor, Fiona and Liz for inviting me to participate in what's such a fantastic programme. And I'd also like to thank the other participants for making it such an interesting and valuable experience. And I hope I'm not about to destroy all that. Okay, so I'm interested in action and in the law's approach to action and in the law's approach to responsibility for action. Now it's important, if we want to understand that we understand what it is that we do, what action is. So what is action? I think the classical paradigm and law's paradigm is this one. First of all, there's a person, there's a mind or a brain, and there's an action. And these are three quite disparate things. The person is one thing, the mind is something else, and the actions that follow are something else again. And this is closely associated with a causal approach to human behaviour. That there's a person with a mind, and the states that the mind are in cause the things that we do. The things that we do at that point kind of leave the mind and the person somehow behind. Now this approach to action is being questioned quite a lot outside law, but I think it very closely matches how law operates. So if I want to sort of translate that very simple paradigm, person, brain, action into law's terminology, into the terminology of criminal law, we have a defendant, the person. We have the defendant's states of mind or their brain. And we have the criminal offence, which is their action. Again, three quite discrete things: the agent, the mind, and the criminal offence. So law and philosophy, at least in its traditional forms, are typically concerned to understand inputs into action, or the causes of action. And these inputs, these causes, are agents, are people, and the states of mind that people have. What concerns me about this paradigm, and there's many things that might concern many from many different disciplines, but what concerns me in particular is that once we act, everything else gets left behind. The states of mind somehow get left behind. The person somehow gets left behind. And the action is something that can be analysed in and of itself. So you might wonder, if all of this gets left behind, what remains? What's left of action? Is there anything left? Well, one thing is left: physical movement. The things we do are physical. We move. Our action is our movement. And again, we can look at this, we can see this as being an idea perhaps associated with law more than it is associated with anything else. So theft, for example. Theft is the dishonest appropriation of property belonging to another, with the intention of permanently depriving the other of it. That's what theft is in law. That's the definition that law gives to it. But any first-year student in law will tell you that things don't end there, because if we want to understand culpability, the thing that's most important in all of this is not the bare definition of theft, but the way in which it can be understood in actus reus and mens rea terms. To put that more simply, the actus reus element of a criminal offence is the physical movements, the physical aspects of it. The mens rea aspect of a criminal offence is the mental element. So, staying with theft, the physical elements would be the appropriation of property belonging to another. That's the physical action that's involved in the offence of theft. The mens rea elements are dishonesty and intention permanently to deprive. And the two things are quite different. The states of mind do not belong to the action at all. The action is just the physical movement. That is, some would say, the essence of criminal law. Actus reus, mens rea. And to be absolutely fair, and I think I would concede this, often this paradigm works very, very well. Often it does a very good job of getting to the heart of culpability. But sometimes it doesn't work so well. And I'd say that's because, in essence, it's flawed. It's not a good account of what human action is like. There are many reasons why that is so, but consider just this one. If you take an offence like murder, the mens rea element there would be intention to kill or to cause grievous bodily harm. The actus reus would be actually causing the death. So imagine then that the victim is killed by shooting. If you want to say that we are responsible for our actions, and that actions are physical movements, and if law is really right in that respect, then the thing that we're responsible for is just the physical movement, pulling the trigger. And that, to me, doesn't make any sense whatsoever. We surely need a richer kind of action, a richer kind of physical movement. So two people who break a window, one in order to escape from a fire, the other to damage the window, they've both performed the same physical actions. They're both, if that's what their action really is, the physical movements, they're both responsible then for the same thing. So there must be something wrong with this idea. And I think at base what's wrong with it is it just distorts what action is like. Human action is not physical movement. It's something far richer than that. And the tendency to focus on the physical aspects of action does a number of things. First of all, it causes us to consider that defendants do the same thing. That defendants are to blame for the same thing. So all defendants convicted of theft, all of them appropriated property belonging to another. And by the way, they had a culpable state of mind in doing it. But since that's not the action, the thing they do is the same. There's no differentiation in the actions that they perform. In law's terms, they've all done the same thing. But, and this is where I think it gets more interesting, and I hope not more complicated, I think law has another account of action too. Another concept of action that sits alongside the physical, mental division that ascribes the status of action just to physical movement. And probably many would disagree with me on this, but in a sense I think it's obvious. So, sticking with the offence of theft, again, the dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it. That's theft. And it's a perfectly natural response to that to say that a defendant committed a theft. That theft is something the defendant did. That theft is an action. If that seems, again, pretty obvious, I think it is, well, at least it's an obvious way to speak about what happened there. It needs to be conceded then that theft incorporates mens rea and actus reus elements within it. That theft as an action isn't just physical movement, it's the physical and the mental combined. It is, I would say, the range of human capacities activated therein. Not just the physical, but any of the human capacities involved. Murder, for example. In murder, the defendant kills, he causes the death of another human being. And he intends either to kill or to cause grievous bodily harm. Now, with the actus reus mens rea paradigm, the physical action of killing, either the basic action of moving a finger or the causal, the full causal event, that's the action. And the mens rea is something else. It's state of mind, it's in the brain of the defendant. It's left behind in the action. But again, it's perfectly natural to say that a defendant committed a murder. That the defendant murdered the victim. And if we want to say that, we're not saying then that the defendant caused the death. There might be legitimate ways in which one agent causes the death of another when they're acting in self-defense, for example. So when you say that the defendant committed murder, that's an action of his, again, that is to say that they've done something that's not just about physical movement. Because murder is an offence that involves actus reus and mens rea. What is done is not just movement. And in fact, if you want to say that it is just movement, well, what does it mean to be responsible for? I think very little. So I think law has two concepts of action, and I think the one we've just been considering is far more plausible than the actus reus mens rea paradigm. It allows us to conclude, for example, that defendants are responsible for their crimes, because crimes are actions. If we want to stick to the mens rea actus reus account of human behaviour, and defendants are just responsible for movements. Now, why is this relevant to any of what we've been discussing today? I should, at this point, confess that I'm kind of outside of my scope of expertise. But I think it's relevant, and I think it might assist some of the ways in which we might think about the experiences that Nick has had, for example. I hope it's relevant because it offers a richer concept of human action. A concept that suggests we act from a range of human capacities, physical movement being just one. And that none of this is left behind when we act. And so all of it is constitutive of the things we do. Action is not physical movement. It's our emotions, it's our knowledge, it's our reasons, and it's our movements. But it is all of that. And if you want to understand what agents are responsible for, you need then to understand all of that. And law, again, does actually recognise this. It recognises a broader concept of action in a number of ways. So again, theft is dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it. So states of mind belong there to the action. Dishonesty is not something that's in the mind that kind of disappears once the action happens. It belongs to the action. Intention permanently to deprive, that's there in the action too. So does law include knowledge, foresight, suspicion sometimes, in its definition of criminal offences. It's relevant in the context of defences as well. So we have defences involving loss of control, duress, diminished responsibility, automatism, self-defense, and even in some cases, in specific intent offences, intoxication. Now, I don't think law is here taking the view that these are states of mind that explain actions. I think rather these are descriptions of actions. So the defendant wasn't in control at a particular point. The defendant killed in self-defense. That's what the defendant did. And defendants in this position don't do the same thing at all then as other defendants. So someone who kills in self-defense has performed the same movement as someone who kills with an intention to kill and without any defence. But we wouldn't say that the person who kills in self-defense has murdered anybody. So we change our action descriptions, not merely by reference to physical movements, but by reference to a whole range of factors that feature in human action. And law already recognises that, if we're prepared to accept that it has a broad as well as a narrow understanding of human action. So I would argue in favour of a focus on action in this richer sense. And if you want to understand action in the context of criminal law, if you want to get to the heart of what makes people culpable, what can exculpate defendants, the first thing that you better understand is what their intentional action actually is. What is the intentional action? What are its inculpatory and exculpatory elements? And all of that requires value judgments, it requires moral judgments about what really does excuse behaviour, or what really does negative culpability entirely. And it also requires law to be nuanced, probably far more nuanced than it is at the minute. And nuanced in a way that rules often find difficult to adapt to. Any system of rules once this is where liability lies, this is where it doesn't. Strict categories, easily accessible, and that just isn't what human action is like either. So a number of things I would say about that understanding of intentional action. First of all, law's domain is intentional action, and just intentional action, because to say that there's no intentional action is just to say that there's no action. And where there's no action, that shouldn't be the concern of law at all. So a defendant who bangs his head or hits on the head, who performs what otherwise would be a criminal offence, shouldn't be assessed, shouldn't fall within the realm of criminal law at all, because their behaviour just isn't intentional. It lacks that voluntariness that goes to the heart of crimes. Someone who has a seizure and an event ensues because of that otherwise would be a crime, again, to me, that just shouldn't be the concern of criminal law. Now that, of course, it might be the concern of many agencies, it might be concern of medical services or hospitals, but any person who, for whatever reason, is involved in an event that isn't an intentional action shouldn't be, to my view, subject to criminal law prohibitions. That is something that falls outside the scope of criminal law entirely. That's not to say that it doesn't fall to be assessed. I mean, someone who bangs their head and is behaving in a very strange way, you'd want to get them medical help. But criminal law. Okay, so where there are intentional actions, does it have the culpable elements understood by law in the broader sense? What other action descriptions are available? And here I think it's particularly important to move away from the physical account of action. Because if you focus on the movements that defendants make, if that's what they do, then there is no alternative description of the action. And again, law itself does provide a richer concept of action than this. But I'd say that it could be even richer still. That there are all sorts of things that are constitutive, that make up the actions that we do. So distress might be a feature of action. Vulnerability might be a feature of action. So might anxiety. Pressure might be a feature of our action. Limited awareness. An alternative understanding of the situation. It's not something divorced from what a defendant does. It's part of what they do. Agitation. Distraction. Excitement. We all behave in a particular way when we're excited. And again, that's not just of our minds, it's of our action. Nastiness. Knowledge. Our reasons for action. The movements we make. The concerns we have. Any action that any person performs can be described taking into account any capacity that's involved in that action. Not just movement, any capacity. Now, I'm not saying that all of those elements of the list you've just seen would operate to reduce liability or to increase it, but I'm saying that it ought to at least feed into the assessment. It might be relevant when it comes to decisions about guilt or innocence, it might be relevant when it comes to mitigation, but probably unlikely ever to be irrelevant. And importantly, if you want to understand action in this sense, if you really want to understand what defendants do, and if action is not about, if the root of culpability is not something that's vests in the mind as a kind of historical fact, then I think assessments of mental conditions, looking at the mind of offenders as though it's something in itself that is useful to analyse, becomes evidentially less convincing. So it suggests that an evidentially broader range of factors might be taken into account when we consider what people do. So that's not to say that medical evidence would be irrelevant. It's just to say that many, many, many other things are likely to be relevant. An observer, someone, a third party who's there, present, watching the behaviour of the defendant, might be able to give a better view of the intentional action than someone who purports to be able to explain what was going on in their head at some point or what mental condition they had. And again, I'm not saying that that will of necessity be irrelevant. What I'm saying is there's room to question the authority given to those approaches. So what is voluntary about the things we do? I would say our intentional actions are voluntary. Everyone's intentional actions are voluntary. But what matters most is understanding what those intentional actions are. For me, they include the person we are, the capacities we have, and the manner in which these capacities are exercised. Everything is taken to action. It's not part of the history, it's part of what the action is. And our intentional actions are voluntary then because they're ours. We act. It's our capacities. When you look at this in the context of responsibility then, criminal responsibility, sure, we're responsible for our actions. We're always responsible for our actions. But if you really want to understand what our actions are, and so what we're responsible for, you need to be attentive to the emotions, to the knowledge, to the reasons, to all of those factors that feed into what we do. How any of this translates into practical ways in which the systems of criminal justice might adjust, I'm not sure. I hope it's not my role to kind of offer those kind of concrete proposals, but I do think that this is a more accurate account of human behaviour and a more humane account too. So, yes, Nick is responsible for his actions, but his actions are constituted by the person he was, by the circumstances he was exposed to, by the distress that he was in. And being responsible for that is something far more different than being responsible just for breaking a window. Being responsible for that is something that I would say systems of criminal justice ought to treat as being entirely exculpatory. If you're responsible for that, criminal justice shouldn't bite at all. Right, I hope some of that makes sense. That's it.
Glad to see you, and thanks for coming. I suppose I'm trying to put my story in context and to give you the relevant parts, which will help a greater understanding of the issues raised by my story. In some ways, it's quite similar. Can you hear me? Is there any need for the? Can you hear me?
Yeah. Either speak up or the mic.
Okay, yeah, I'll speak up. It's good enough. Yeah, we'll do it naturally. What was I going to say to you? My story, in some ways, has resonances with Nick's. There are certain similarities. I suppose the gradual escalation of the offences and the reason behind it were not how they appeared, obviously, to the judicial system. First of all, I was involved in a harassment incident when I was in my late 30s with a younger woman, a much younger woman, and this came before the courts after escalating, and by escalating I mean by being badly handled by all concerned, including myself. The girl was only peripheral to this. It was how the authorities handled it and how I handled the authorities, and the fact that I wasn't fully cognizant or aware of the significance of my actions, and by that I mean not that I wanted to, that I was supposedly harassing a girl. I was well aware of all that, but I had, first of all, what for me were very good reasons, and they were creative reasons, and which which were relevant to my actions. And that is what I hopefully will show to you later on, is a theme which is also talking, Maria will be talking about the real motivation for people's behaviour. But having said that, the whole incident was badly handled, and partly because I didn't receive the right kind of advice to make me aware of the consequences of the approach I was taking. That's what I want to say. Because I was taking the wrong approach, and that because I defended myself. As it happens, the event, talking about being culpable and being responsible, it was decided I was culpable even before it came to trial, and that is blame and moral judgment. So I was immediately, the assumption was that the conclusion was that I was a pervert. Because I was doing something which was socially unacceptable and sexually deviant in the eyes of what is the moral judgment of society. But having said that, I was sent to the Central Mental Hospital. So there are issues there which Maria will develop, and we're going to talk together afterwards. So I'll elucidate and clarify those points when appropriate. But I was actually put on medication and given a very heavy dose of medication on the morning of my trial. I was defending myself because I wasn't receiving the right kind of advice and support, including I was being instructed by my solicitor, and even that term means that you're told what to do. I wasn't. That isn't the way I operate. I can be perfectly reasonable if people are reasonable with me, but sometimes people think that being reasonable means doing what you're told. So anyway, just to say, I wasn't aware of how to correctly conduct myself in court. I wasn't given any direction from the judge, who had quite clearly made up his mind, even without any of the evidence. I had pleaded not guilty. Now, I have to clarify that, because in one sense, and this is where we're talking about kind of intention, I was responsible for making a nuisance of myself. I was obsessed with this girl, okay? That is a fact, okay? I hadn't, I had only seen her on a couple of occasions, but I was, as they say, making a nuisance of myself. So these are all facts. But my reason for doing it, and that's what I'm saying, were reasons which for me justified my action. I can go into much greater detail, but that will hopefully, it'll all come up in the book, folks. But anyway, just to go on, because we're also talking about incidents which might give you an insight into the kind of person I am, but which on the surface can be judged, and I suppose if you're to make a real assessment of who I am, and the reason for my actions, and whether I was criminally responsible for my actions, this is putting it in context. The second incident was a nude sunbathing incident in a local park down in Cork. Beautiful sunny day. As far as I remember, there was a match on. I suppose I got fouled early on. No, but the fact was, I was told by a park attendant, happened to be a woman, put on my clothes. I felt there was no reason to put on my clothes. I was enjoying the sunshine. It was something on a personal level. I think that I see no shame in nudity, and I actually fell asleep. So it came up. I was arrested by the guards, and I was so annoyed at the conclusions that they must have come to, and at such a stupid law that I refused to put on my clothes and was taken naked in the car to the police station where I was held naked. And it's very interesting. There was one of these kind of functionaries, as they say, one of these kind of guards who had a job in the station, and I do remember him, coming up to the door and sniggering, Now, to me, that is a reflection of the society in which we live, and not in the not on me as a person. But the interesting thing is, it got before it was kind of it was reported, and there's also things like pervert in the park and stuff like that on the radio, and there's all sorts of conclusions again and moral judgments being made on the incident. Look, I have no problem. Look, there are things that we all disagree with in society, and we kind of bite our lip and we put up with them. Because if we want to challenge them, or if we want to take an action against it, that is our choice. Okay. Look, as I was saying, in Saudi Arabia, you're not allowed to kiss in public. So that's the way they do things, and fair enough. If you kiss in public, you accept the consequences. But it is the conclusions that were drawn from that action, okay? And that is what really got me. That I was a pervert. That I was doing something something dirty, kind of but anyway, so this is all about how I see responsibility and criminal responsibility, and where it is appropriate. We have been talking about what is a crime, and that is that we were talking about that yesterday. I don't regard those two incidents as crimes in any way, but that's my own conclusion. I have a criminal record, which is a fact, and I suppose I've been lucky enough to get involved in this project to put forward my analysis, for want of a better word, of the situation, and where my experience applies to the CRPD. So they're very small incidents. They're just me, but they have a wider significance in terms of the conclusions that can be drawn from them. So anyway, and the changes that could be made to respect equality before the law, and let's get back to the point, because in terms of equality before the law, on each occasion, even though I have a history of mental health, I insisted on to what I wanted was a trial by my peers. Now, a trial by my peers is what I consider a fair. It should be what I consider a fair trial. But I have pointed out to you some of the some of the, just to put in terms of context again, I received a 2-month sentence for the nudity incident, and well, of course, I made a mockery of the courts as well. I was defending myself, and again, was derisory about the charge. But I received a 7-month sentence for the incident with the girl, which in other societies, is regarded completely differently. But to get back to the idea of equality before the law, on the third incident, which was serious, and we're talking about escalation here, because I found myself in prison. As you can tell, at that time I was quite unreasonable, inverted commas. I had a disagreement with the social welfare officer, the social welfare officer in the prison, who represented for me all that I consider wrong with our society. He denied he wouldn't reinstate my social welfare benefits, so I was homeless when I came out. And I decided that I was going to follow my dream as I had intended at the start and become an artist. So I committed a crime, and I use that word advisedly. I consciously and deliberately slashed some tires. Okay, I was quite rational in one sense. I wanted to go to prison for quite a long time because they had a great library of art books and that, and I thought I could study there and nobody would annoy me, and I could educate myself in the way that I wanted to be educated. It didn't work out like that. But it made perfect sense to me at the time. Anyway, the question of capacity came up, and in the trial, and I was insistent that I be trialed by I get a trial. Now, first of all, the police handle the situation much better, and these are lessons that Marie will be talking about. The things that we can learn from this, and the difference in subsequent action which happens. I was treated with real respect by the police this time, and I wasn't prejudged, because obviously they knew I had done something, but they said, "Why did he do it?" And if they had really wanted to find out what the story was, they would ask me how I felt about how I was treated. But that's not the way the law works. But anyway, I was treated well by the police, who gave me access to all the things I required, and facilitated the necessary things like, and equally on this time, I realised that this was a serious incident, and I was well aware of the fact that I was doing something wrong. This was a serious incident. I had slashed about 30 car tires outside a hostel because they refused to allow me to wash and cook, even though I offered to pay them. Wash and cook in the area, but it was in the area where I was skipping out. But to me that was a perfectly reasonable kind of an offer. It was quid pro quo, but they obviously felt that if they allowed a homeless man in their premises, it would somehow contaminate the clean atmosphere. But anyway, and I like cooking. But anyway, so that's the basis of the crime. But the fact is, it was treated seriously, it was taken seriously. I received my rights, and I received due respect, and that included the judge asking me whether, asking my counsel, and through them, me, whether I was fit to plead. Now I knew I was fit to plead, and even if I wasn't, I would have insisted, because fitness to plead can be kind of defined in different terms. A psychiatrist who was a prison psychiatrist, and also my general psychiatrist, with whom I had a lot of disagreements, he testified, the expert again, that I was fit to plead. The trial went ahead. The judge made an effort to comprehend the situation, and I got a 3-month sentence for this, which was a far serious offence of far greater gravity than the other two. But I actually served a 6-month sentence, which in my mind was fair, because I had to go to one of these involuntary detention hospitals, psychiatric hospitals, for 3 months. So I was medicalised, but the interesting thing is, let's consider what my option would have been if I hadn't taken the action that I did, which was purely instinctive at the start. It was just based on a belief that, that 10 minutes left there? Yeah. Oh, I better... I'll make the point, I'll just make the point. If I hadn't, right, I would have been adjudged unfit to plead, in not lacking capacity, first of all, and I probably would have ended up in the psychiatric hospital, and as I said to Maria, I'd probably still be there and 20 stone. So in some ways, even though the law treated me very harshly in my view, it actually denied me the self-expression to which I think everyone is entitled to. It could have been a lot worse. So I finish on that. It's going on.
Yeah, this one. This one, yeah.
No, it's good. Yeah.
Okay. Yeah, I'd rather do it without microphone. John and I started talking way back in June. We should have started earlier probably, but we started in June. And our first ideas was coming across what criminal responsibility means to him, to me, to us, as society, and then lots of thoughts came in. And the good thing about working with John, who's been through it, is that you put an idea and it comes straight back like, no, this doesn't work, or this doesn't work, this, I don't get this. And one of the things I came through is that all acts actually mean something. When you do something, there's a meaning in it, and that we should look at a criminal act when it comes up as something that is telling you that there's something wrong, rather than looking for the guilty person, which is what we tend to do. And we should look at what's wrong. Maybe the rule is wrong, like in John's second incident, at least in our opinion. Or there's something wrong with the situation, there was a lack of support to make a decision, or actually the person could be guilty. And then we pass to the point we think that for every act we need an appropriate response, which might not be in criminal law, or if criminal law wants to be the response, it has to open its way of responding. I'm going to go a bit, not through all the ideas because we don't have that much time, but one thing that was really important for John, and I only understood when I talked to him, the wording of law. He criticized that we actually say plea guilty, because he thinks there's a position within that, and that's something that never occurred to me. And then one of our big discussions was, what if legal capacity is something negative? What are the outcomes? And then we realized that we want to avoid negative outcomes like prison, because prison is a horrible place, you don't want to send anybody in there. And then we realized, well, maybe we have to change prison. That's not the topic here. But we're aware that that's something that's behind our thoughts sometimes, and that's something that concerns everybody when talking about criminal responsibility. As John told you, there's a difference between an informed defense and instructed defense. One thing that happens across all jurisdictions, I think sometimes a lawyer comes in and tells you, you should plead guilty because that's much better for you. And you haven't really understood why would that be better for you, what's the alternative. and you don't get to decide. And that doesn't matter if you have the capacity and it's not being questioned. It happens all the time, but within disability, or when people with disability come into court, it happens even more, that people decide for them all the time. And it's very important that we instruct the person, that we inform the person, not instruct, that we inform the person of what the options are and what the outcome is. Because once we, like, I think one of the things we have that is a problem is that the rights of the detained person, for instance, have been written by a person who knows the system. Whereas when I come in as a detained person, and I'm not a lawyer, for instance, imagine, I don't know the game, I don't know what's going on, I don't know what is at stake, so those rights are not going to help me, because I don't know what they mean. Even though I understand I have the right to a lawyer, I don't know why I would need a lawyer, because I don't know what the next step is going to be. So it's highly unlikely I'm going to say, yes, I want a lawyer, if I don't know that the next step is going to be a judge asking me questions. Or if I don't know that if I decide not to have a lawyer, I could be deciding things that have implications in my future, like my job, my next 24 hours, my next 7 hours, my medication, my mental health. Then one of the things that I think John's story shows, and he highlighted it already, is that he was treated medically even though he didn't want to, and especially he was given medicine on the day of his trial, even though he didn't say that, but he actually offered to take it after the trial. Like, let me be at the trial, and then when I come back from it, you can give it to me. I think those actions are actually a way of punishing people without a way of defending themselves against that punishment, because we give them medicine, we take their social benefits with them, and they can't really, there's no tool for them to say, I don't want this because there's nobody listening, and the person who has the authority is given that authority by the system, by the law, or by the judge. That's one of the things we have been highlighting today, is that often the doctor becomes the judge. That means that because the judge decides he has no idea about a person with disabilities and mental health issues, I will rely on a psychiatrist, and then whatever the psychiatrist says is going to be decisive. So any pretrial detention guarantees disappeared. John didn't tell you this, but during the first incident he was put into pretrial detention at a hospital, and none of the checks Florencia talked about were considered. It was just like, okay, he has mental health issues, that means dangerousness, and we'll put him there because that's going to be the best place for him to stay. I think in that sense, neither the judges nor doctors have assumed the CRPD definition of what a disability is, and they just look at it as from a medical perspective, when the CRPD actually has rejected that definition. One of the things John highlighted from his third incident as a big difference was the respect he received from the police and from the judge. I think that's something we always give for granted, and we think we're all respectful with people, and we're actually not. And I think that's something I try to implement when I give my talks to police officers back in Spain, and I think that's something we kind of need to insist on, especially. We talked about communication during procedures, that you're especially made aware of the outcomes of your actions, and that you should not be threatened with the consequences. One of the things that often happen is that people are told, if you don't do this, this and this will happen, instead of making you aware of that you have different options and what goes with each option. I think we need to be creative and open with people's needs for communication. One of the things I realized is that we expect, like from the system point of view, like the police, lawyers, and people who are not within the disability world, we expect that when a person comes with a support person will talk. And we expect the same sort of testimony or answer that let me see, how should I say this? We want to make the disability, the difficulties disappear through the support, and that doesn't happen. The support is there to make the person comfortable to speak and to say it in their way, and we have to accept their way. But a good example would be, in Spain, they've realized that when people stutter, they think they're lying. Okay, so you cannot make a person who stutters stop stuttering, but you have to believe them, and you have to take a step over that stuttering and think, okay, and I'm going to question if he's saying the truth, it should be on a different basis, not on the stuttering. That would be being aware of our own interpretations of disabilities and of how people come across. I think the labeling has been mentioned a couple of times. It was especially harmful for John because it pre-decided basically everything in his first two trials and in the way he was treated afterwards, and even from his mates in hospital and prison. I think you had.
Oh yeah, you know, I want to go to the prison incidents because they were very unpleasant. But yeah.
During the entire day we've been speaking about support. John actually called it facilitating, which I like because it goes both ways. We facilitate the person with disabilities and we facilitate the other person. It's important that it's there from the very beginning to the very end, and the end should never be the day the punishment stops. If you let the person out from prison and you let her without support, there's very little that person can start doing, because the harm of prison is not just that you've been deprived of your freedom, but obviously, and I think nearly always, you have less money because you haven't been working or you haven't had access to your income resources. I think it's important that we know or that the person is clear on what they need to know in each phase, and that's something I would like to reflect on in the next couple of months. What is it necessary for a person to know in each phase of their criminal justice system? I think there's so much knowledge out there and we're not sharing it. I think so many people have gone through the criminal justice system and know what happens and what would be helpful. And I think we need to share it and we need to listen. And then I also think we need to support the people who are around the person with disabilities, like families, other supporters. We need to give them information, training, or whatever. We need to support them. They shouldn't be alone out there. I think we're out of time. Let's see what else is really interesting. Oh yeah, I'll highlight the last idea is that we were talking about changing the role of the doctor within the procedure, that they should not be serving the judge, but they should be appointed by the defendant if necessary, and that the defendant gets to choose who his doctor is and what the doctor is going to reveal about his medical history, whether it's relevant or not to the case too. I think that was one of the specific ideas we were discussing. And I think that's it, and you have time for questions.
Thank you.